Well, today we are going to see very important topic, that is the new labor codes. It's an event which has changed the laws of past over 100 years or 102 years, starting from 1923 to 2008. And now 29 labor acts have been repealed. And since 21st November 2025, the new labor laws have been implemented in India. It's a phase-wise implementation for two codes, and all say four laws have come into effect, except for a few provisions that we shall see. So it's a much simplification. And the good news for law students is that it will be only 40% of the syllabus. So the new laws are much simpler and better than the previous ones, having multiplicity of laws. So this is the consolidation of Indian labor law that has happened, and it was that exercise was going on since 2019-2020. But earlier there was COVID, and after COVID there was another problem, that is the state rules. Since labor law subject in constitution in the concurrent list, therefore the state governments also had to notify the rules. Now that most of the state governments have notified the rules and the laws have come into effect, the remaining state governments will also follow very soon. And the notifications are being published every day on the Ministry of Labor and Employment of Government of India, as well as on the state government websites of their labor departments. So we are going to have a comprehensive overview. Actually, this topic is very big and it's not possible to cover it within, say, one lecture, but maybe we shall have a series of 4 to 5 different lectures, and we shall see each of these sessions in detail. So these have come into effect from November 21, 2025, and it is the biggest labor reform since independence, because we know about the industrial revolution that started in 18th century. Earlier there was this say slavery, that is gulami pratha, and then the industrial revolution started with steam engine and 19th century, 20th century, and then electricity, steam engine, many things were invented, and then the factory was defined. Now the Factories Act has also been repealed. So 29 central labor laws have been consolidated into 4 comprehensive labor codes. And earliest one is the Employees Compensation Act. Earlier it was Workmen's Compensation Act, 1923. Up to 2008, the laws have been now repealed, and still there are some laws that are in force. So we shall see, because labor law is a very important, uh, paper for LLB students as well as for practicing advocates, those who are practicing in, civil courts, as well as those who are specialized in labor courts. So for them, this webinar will be very useful. The law were enacted between 2019 and 2020, passed by the parliament, and notified by the president. The assent of the president was got, but the recent notification has come into effect on 21st November. So many laws were framed in pre-independence and early post-independence era. Some of them were before 1947, like Industrial Disputes Act 1947, Trade Unions Act 1926, and many laws were during 1930s to 1950s. After the Constitution of India came into effect, there was a need to change the laws and make them in accordance with the Constitution. So most of these laws were fragmented. They were very complex, outdated, sometimes redundant provisions. So this created uncertainty and compliance burden on workers and industry. Now we are going to see there is going to be much simplicity, because single registration will be sufficient, and this needed alignment with modern global trends, because India is also member of ILO, International Labour Organization, a body of United Nations, and therefore these laws have to be aligned with our international commitments and evolving the employment patterns, because now we have gig workers, we have also people who are working online, people who are working having work from home. So as per the press release from Press Information Bureau, Ministry of Labor and Employment, in November 2025, they have published a booklet on the Ministry of Labor and Employment giving the benefits of these laws. Now there are 4 different codes. These are comprehensive, so they are called as codes, just like we had code on, say, insolvency and bankruptcy, IBC, or we have, say, CPC, CRPC, or say Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita. So these are also called as codes because they are comprehensive. They are bigger laws as compared to the smaller acts of, say, few sections. Now there are only 480 sections as compared to the 1024 sections before in those 29 laws. These laws are the Code on Wages 2019. Second is the IR, that is Industrial Relations Code 2020. Third is the Code on Social Security 2020. The fourth is the Occupational Safety, we call it OSH, Occupational Safety, Health and Working Conditions Code 2020. The first one was Code on Wages, which was notified on August 8, 2019. Almost say 1 year after that, on September 29, 2020, the remaining three acts were notified. But even after notification, the exercise was going on because there were some negotiations that were going on with the industrialists as well as with the labor unions. And we know about there are bipartite, tripartite settlements, as we know from the Industrial Disputes Act. Now the Industrial Disputes Act has also been repealed. And now there is going to be IR, that is the Industrial Relations Code. So what are the changes? So we see that the Payment of Wages Act, the another one is the what are the laws that are repealed. So the Code on Wages repeals Payment of Wages Act, a very old one, 1936. Minimum Wages Act 1948, that has been repealed. Payment of Bonus Act 1965 and Equal Remuneration Act 1976, that promise equal wages for say men and women. So these laws have been repealed completely. It has come into effect in two stages, but now the Code on Wages has been implemented completely, and all these four laws have been completely repealed. So there is universal minimum wage coverage, and there will be a national, say, wage that will be there. Earlier, it was different from state to state. It was called minimum wage. There were, say, starvation wages, peacetime, or say, time rate, different rates were there. Now, for timely payment of wages, there was a law called Payment of Wages Act, that wages should be paid, say, from on 7th day or the 10th day, and various provisions were there. All these overlapping and staggered, say, provisions have been consolidated. There is equal remuneration without gender discrimination, but besides the woman, now third gender has also been taken into consideration. For payment of bonus, there was Payment of Bonus Act that has been repealed. Earlier, there was 8.33% bonus. And National Floor Wage Mechanism. This is a new term that has been introduced. National Floor Wage. Floor is the minimum wage. So that minimum wage has to be paid. Above that, the state governments may pay more than that. So, and we also have to remember, this is not a wage commission. Salary kitna badha, kitna badhenga, that is not a consideration at all. That happens every 3 months, 6 months, 10 years in pay commissions. We are not concerned with that. Here we are talking of once in a century event. That is how the laws have been changed. So that is the major consideration, rather than whether it will be beneficial or say, because the benefits will be long term. So we shall see this one by one. The second one is Industrial Relations Code, IR Code. It repeals the three laws, that is the Trade Unions Act 1926, which recognized trade unions and gave immunity to their office bearers. Industrial Employment Standing Orders Act 1936. So 1946. So there are some model orders related to various, say, issues that can be used after some modification by different industrial establishments. So that has also been repealed. And Industrial Disputes Act 1947, which was there to resolve the disputes between management and workers, and sometimes with the help of government also. The key focus areas of IR code are trade union registration and recognition. Earlier there was registrar of trade unions, but now there will be much simplicity in registration process. Standing orders for industrial establishments, that is the Industrial Establishment Standing Orders Act. Third is Industrial Dispute Resolution Mechanisms, strike, lockout, etc. The IR code will deal with that, retrenchment, etc. Strikes, lockouts, layoffs, and retrenchment. These are the critical issues. For that, the some of the provisions have been changed that we shall see today. And fixed term employment provisions. So even those who are employed, say, for fixed term, they have to be given appointment letters compulsorily. These are some new provisions that we are going to see shortly. The third one is the, say, the code on social security, SS code we shall call it. It repeals 9 laws. So first is the Employees Compensation Act. As we know, earlier it was Workmen's Compensation Act. Now it is renamed as Employees Compensation Act 1923. Now it is repealed. Employee State Insurance Act 1948, ESI. Some provisions of ESI and EPF are still in force, and about in 1 year they are likely to be repealed. I will go into details later. So the Employees Provident Funds and Miscellaneous Provisions Act 1952. Don't confuse that with GPF. For government employees, it is GPF of 1925. Here it is EPFO, Employees Provident Funds, that is for 1952 for industrial employments. The Employment Exchanges Compulsory Notification of Vacancies Act 1959, because now all these employment etc. are advertised online, and these traditional employment exchanges are not there, but there are campus placements through universities and colleges. So it was an old law that needed to be repealed. The Maternity Benefit Act is repealed. It is replaced by a small chapter now, and there are, say, better provisions now. There is a Payment of Gratuity Act 1972. At the time of retirement, a lump sum amount is given. So the Payment of Gratuity Act is also repealed. Senior Workers Welfare Fund Act 1981. There are two different concepts: welfare fund, welfare cess. Fund depends on the number of employees. Cess depends on the production. So this Fund and Cess Act, these are different. So out of that, the Senior Workers Welfare Fund Act has been repealed. It includes not only actors and actresses, it also includes makeup artists, technicians, and all other types of senior workers. The Building and Other Construction Workers Welfare Cess Act 1996. Cess is different from welfare fund. It depends on output, production. The Unorganized Workers Social Security Act. So it was already named as SS Act, and now we have SS Complete SS Code. So all these 9 acts have been repealed, except 1 or 2 that will be repealed soon. So few sections, 3-4 sections of that yet to be repealed, because there are crores of people, and now instead of 20 crore people, it is going to affect around 60 crore people. We shall see that shortly. So the key focus areas of SS Code are universal social security coverage is there. In USA also there is concept of social security, and there is social security number that is unique, that is given to all employees. SS number. Here we have Aadhaar number. So now social security coverage has been expanded. Then gig and platform workers. This is very important consideration. Gig workers are like e-commerce, or maybe like people who say bring the groceries to our home. That is through e-commerce, Snapdeal, Amazon, Flipkart, or maybe Ola, Uber, Rapido, taxi, and people who are working platform workers. That is, say, people who are working on Fiverr, Upwork. These have also been included. So work from home has also been covered in this. So gig and platform workers have been included for the first time. This is a new provision. Then provident fund, employee state insurance, ESI, and gratuity. So these have also been included within social security. And there will be provisions for pension, etc. for these gig and platform workers also. Maternity benefit and compensation. So that has also been being changed. The fourth one is OSH code. Actually, it is OSH and working conditions. So occupational safety, health, and working conditions, which replaces the Factories Act. Factories Act was the most comprehensive act after independence, as we know. The Plantations Labor Act 1951 for different plantations. The Mines Act 1952, General Act. There are special Mines Act also that we shall see after this that have not been repealed. The working journalists and other, say, newspaper workers, newspaper employees, conditions of service, and miscellaneous provisions Act 1955. There is another working journalist, that is conditions of, there is fixation of rates of wages at 1955. So both these acts have been 58. Both these acts of 1955 and 58 have been repealed. Next is the Motor Transport Workers Act, that is driver, cleaners, etc. 1951. That has also been repealed. There are 13 acts that have been repealed. So the BD and cigar workers, Conditions of Employment Act 1966. Another is the Contract Labor Regulation and Abolition Act 1970. That is also repealed. The Sales Promotion Employees, that is salesmen, sales girls. So Sales Promotion Employees Conditions of Service Act 1976. That is also repealed. Then we have the interstate migrant workers. That is people who are moving from one state to another state. Regulation of Employment and Conditions of Service Act 1979. That is also repealed. The cine workers and cinema theater workers. Regulation of Employment Act. See, this is the different act for related to cinema workers. 1981. Then we have dock workers, people who are working in dockyard, bandargah, godi, we call it Marathi. So that is Dock Workers Safety, Health and Welfare Act 1986. And then we have the Building and Other Construction Workers, that is Regulation of Employment and Conditions of Service Act 1996. So some of the unorganized sectors have also been included, and now these are the 13 acts that has been repealed by the OSH, or it is actually OSH and Working Conditions Code that has been changed. So these are the 4 new codes. Now this is the list. Now if we compare from academic point of view, particularly from student point of view who are worried about their syllabus, the laws, नए कानून पढ़ना है कि पुराने कानून पढ़ना है. So many questions could be there. So first we shall see the statistics. The code on wages is of 69 sections, no schedule. It replaces payment of wages at 1936, having 32 sections, minimum wages at 1948, having 38 sections and one schedule, payment of bonus at 1965, having 41 sections and four schedules, equal remuneration at 1976, having 18 sections. The other one, Industrial Relations Code, IR section, now has 104 sections and three schedules. It replaces trade unions at 1936, having 35 sections, Industrial Employment Standing Orders at 1946, having 15 sections and one schedule, and Industrial Disputes at 1947, 83 sections and five schedules. The third one is the Code on Social Security, having 164 sections plus seven schedules. It replaces Employees Compensation at 1923, having 47 sections plus four schedules. ESI, Employee State Insurance at 1948, having 139 sections plus three schedules. Employees Provident Funds and Miscellaneous Provisions at 1952, having 68 sections and four schedules. And Employment Exchanges, Compulsory Notification of Vacancies at 1959, having 10 sections. Maternity Benefit at 1961, having 34 sections, is repealed. Payment of Gratuity at 1972, having 19 sections, is repealed. Senior Workers Welfare Fund at 1981, having 11 sections, is repealed. And Building and Other Construction Workers Welfare Cess at 1996, having 15 sections, is also repealed. Then Unorganized Workers Social Security at 2008, having 17 sections. This is the latest act of 2008 that has been repealed by this code. Coming to the fourth code, OSH, that is Occupational Safety Health and Working Conditions Code. Now it has 143 sections and three schedules. It repeals factories at 1948, having 141 sections plus three schedules. Plantations labor at 1951, having 61 sections. Mines at 1952, having 98 sections. The working journalist and other newspaper employees, conditions of service and miscellaneous provisions at 1955, having 33 sections and one schedule. The working journalists, fixation of rates of wages at 1958, having 15 sections. And the motor transport workers at 1961, having 40 sections. Plus some other acts that have been repealed: BD and cigar workers, conditions of employment at 1965, having 45 sections. Contract labor regulation and abolition at 1970, having 35 sections. Sales promotion employees conditions of service at 1976, having 13 sections. Interstate migrant workers, workmen, regulation of employment and conditions of service at 1979, having 36 sections and one schedule, has been repealed. Cine workers and cinema theater workers at 1981, having 26 sections, is repealed. Dock workers safety health and welfare at 1986, having 25 sections, is repealed. And building and other construction workers consolidation, regulation of employment and conditions of service at 1996, having 15 sections, is repealed. If we see the summary, then we know that from 29 acts, now it is only 4 codes, 25 or fewer. Thus, there is 86% reduction if we see the number of acts. Secondly, if we see the total sections, 1204. And remember, I have included all the sections that were inserted through amendment also. Okay, because that is the correct way. Don't say that CRPC had 484, because CRPC didn't have 484. There were many sections that were inserted through amendment. IPC did not have 511. 511 was the last section only. That doesn't give complete picture. There were many sections that were included through amendments. Similarly, like in case of criminal laws, in labor laws also, these are the number of sections that were actual sections before repeal. So don't refer to only the last section, but the complete act. Now it is reduced to 480 sections. So 724 sections have been reduced, and it's going to reduce. They have a great simplicity that we shall see. So these are just the statistics that we are looking at present. 60% reduction size wise. So that's why I told that syllabus is now only 40% almost. Total say schedules. Earlier there were 27. Now there are 13 schedules. So 14 schedules are less to study, and there are 52% say schedules say reduction is there. And then the period covered. Earlier, the acts were from 1923 to 2008, but now there are only 2 codes, 2019-20, but they have been implemented only recently, that is on 21st November 2025. Now we see the code-wise picture. So OSH code, 143 sections and 3 schedules. It replaces 13 acts and 583 sections and 5 schedules. SS code, Social Security, 164 sections and 4 schedules. It replaces 9 acts and 360 sections and 11 schedules. Industrial Relations Code, IR code, 104 section and 3 schedules. They replace 3 acts having 132 sections and 6 schedules. And code on wages. So it has only 69 sections now, no schedule, because that will be taken care of during the rules. Some rules have been notified. Some rules are yet to be notified. It replaces 4 acts and 129 sections and 5 schedules. Thus, overall, now there are only 480 sections and 13 schedules instead of 29 acts, 1204 sections, and 27 schedules. And as I have told you, I have also included the sections that were added through amendments rather than the only the considering only the last section. Okay, from India Code website. Now it is not correct to say that all the old labor laws have been repealed. What are the old laws that will continue? So let us have a list of that. The old labor laws that will continue in force include Apprentices Act 1961. These have not been repealed. Collection of Statistics Act 2008. BD Workers Welfare Cess Act 1976. BD Workers Welfare Fund Act 1976. Indian Boilers Act 1923. The word Indian is there because it was made by British Parliament before independence. So they added the word Indian. After independence, we stopped adding the word Indian to the Indian acts. Bonded Labor System Abolition Act 1976. Child Labor Prohibition Act Regulation Act 1986. Children Pledging Act Regulation Act 1986. Children Pledging of Labor Act 1923. Senior Workers Welfare Cess Act 1981. Remember, Welfare Fund Act has been repealed, not the Welfare Cess Act. And Coal Mines Provident Fund and Miscellaneous Provisions Act 1948. Also, we have some other say acts, that is that remain in force. Dangerous Machines Regulations Act 1983, Dock Workers Regulation of Employment Act 1948, Immigration Act 1983, that is people who are going from one state, say India to outside, that is immigration. Those who are coming from India outside to India, that is called immigration. So import export, remember the word I and E. Immigration are people who are going outside India for employment. So Immigration Act is for them. Immigration is people coming from outside India to India. Then Employees Liability Act 1938, Environment Protection Act 1986, Fatal Accidents Act 1855, Industries Development and Regulation Act 1951, that was passed by Jawaharlal Nehru government to bring in industrial revolution. IDRA, don't confuse that with IRDA Act, insurance. Iron ore mines, manganese ore mines, and chrome ore mines. Labor Welfare Cess Act 1976, because these three ores generally occur together, and manganese, chrome. Then iron ore mines, manganese ore mines, and chrome ore mines. Labor Welfare Fund Act 1976, that remains in force. Next, labor laws, exemption from furnishing returns and maintaining registers by certain establishments Act 1988, that remains in force. Limestone and dolomite mines Labor Welfare Fund Act 1972 remains in force. Mica Mines Labor Welfare Fund Act 1946 remains in force. And Personal Injuries Compensation Insurance Act 1963, that remains in force. Public Liability Insurance Act 1991 remains in force. Weekly Holidays Act 1942, by which there is 1 day holiday, need not necessarily be Sunday. It could be any day for shift workers. So that was already repealed in 2017. So actually that is not in force now. And Punjab Shops and Commercial Establishment, actually it's a state act 1958. So these are the laws that remain in force. Now coming to the real part, that is the overview of this law. So before the codes, there were 29 separate laws with different say definitions, multiple registrations, that is up to 8. Now there will be single registration, multiple licenses, that is 3-4 different types of licenses had to be obtained, different wage definitions across laws. So the what is included in wage and what is not included in wages. So there are different laws like payment of wages act, minimum wages act. Then fragmented say enforcement mechanisms were there, and Inspector Raj culture was there. Now the role of inspector has been changed to inspector cum facilitator. So after the code, there are 4 comprehensive codes with uniform definitions, single registration system, single license requirement, unified wage definition. That is, there is 50% rule that net pay can't be less than say 60%, 50% of the gross pay. So we shall see what is this unified wage, streamlined compliance, inspector cum facilitator approach. So there is cost to company CTC concept, and because of CTC, particularly the private employment, that is going to be changed. So we shall see what will be the changes. Now the major changes are, firstly, the universal coverage, that is minimum wage now applies to all workers, that is organized as well as unorganized. Secondly, previously it was limited to scheduled employments under minimum wages act 1948. Now uniform definition of wages. So wages must constitute at least 50% of total remuneration. So that is an essential requirement. That is what is included within basic pay, because everything is sometimes as a percentage of basic pay. That is gratuity, bonus, HRA, and many other things that are calculated as percentage. Therefore, now this definition is wages must constitute at least 50% of total remuneration. It can't be less than that. That is very important. It excludes HRA. There is difference between HR and HRA. House rent allowance is given by employer to employee. House rent is paid by employee to employer for those who get government quarters, or say those who get quarters from their company. Bonus, traveling allowance. So HRA is a type of allowance. HR is a type of deduction. It's called license fee also sometimes. The wages excludes HRA, bonus, traveling allowance, conveyance, and special allowance. While if expenses exceed 50%, then the excess is treated as wages. So that is how the definition of wages has been substantively modified now. Next, national floor wage. So instead of minimum wage, the concept is now floor wage. Earlier there was, say, starvation wage, say different types of time rate, piece rate were there. And those were revised every 3 months. But in actual practice, we saw that even every 3 months, the deputy labor commissioners who are responsible for implementing this, they are generally also presiding officers of labor codes, which implement about 51 laws that we have seen just now. So now their central government will fix the floor wage, and state minimum wages cannot be lower than floor wage. So since it is a in concurrent list of the constitution, state government can also say have minimum wages, but it will can't be lower than the central wage based on minimum living standards. So based on living standards, and it is say revised every 3 months or 6 months as per the CPI, Consumer Price Index, prices of essential commodities, etc. Now equal remuneration. So gender neutral provision, it includes transgender. So that is a earlier it included only women. So now these have also been included. Equal pay for equal work or work of similar nature. So although Equal Remuneration Act 1976 has been repealed, but the provisions have been included within this code on wages. No discrimination in recruitment or employment conditions. And now women have also been allowed to work during night times, subject to consent and security. We shall see that. So now the code on wages, applicability. Earlier it was to scheduled employments only minimum wages act. Now it includes all establishments and workers. Wage definition was different across 4 laws. Now there is uniform definition, 50% minimum. Floor wage concept is there. So earlier there was no provision of floor wage. Now there is national floor wage introduced. Payment timeline was, say, varied by law because there were different laws. Now it is standardized for all workers. Gender equality. So earlier there was equal remuneration at 1976. It is repealed now. So it is expanded to include all gender identities, including transgenders. Registration. So there were many separate registrations for each law. Now there is single registration. So that simplifies the process. And then there was an inspector. So there was Inspector Raj, or say traditional inspector, but now there is inspector come facilitator. So the role of factory inspectors have also changed. Now the code on wages, section comparison. So these are some old sections, the subject matter, and these are the new sections under the new code. So payment of wages at section 3. So now there is section 1(4), section 1 subsection 4 of code on wages. Payment of wages at 1936 section 5 was there. Now there is section 17. Minimum wages at 1948, section 3. Now it is replaced by section 6 of code on wages. Minimum wages at section 12. So now it is replaced by section 10. Payment of bonus at say section 4. Now it is replaced by section 26. Payment of bonus at section 10. That is replaced by section 27, 28. And equal remuneration at section 4. Now there is section 3. Of course, these are not the long tables like we had in case of IPC, CRPC, and Indian Evidence Act, like in criminal laws, because there is substantive reduction here. As we see from 1204 sections, there are 480 sections, and therefore direct one-to-one mapping is not possible for all the sections, because there are many new provisions, and most of the say almost 60% of the old provisions have been repeated. Coming to the IR code, so major changes from old laws, the trade union. So recognition is based on the 51% membership, that is sole negotiating union. Otherwise, this was the say old concept. Otherwise, negotiating council was formed. Previously, no specific recognition mechanism was there. For standing orders, application to establishment with 300 workers. So it has been increased from 100. So these are the changes. So there will be trade union, and there will be trade union council also, negotiating council. So this negotiating council is a new concept in the new law. Then earlier there was registration with the registrar of trade unions. So there was no specific recognition mechanism. Now, instead of 100, if there are more than 300 workers, then only union can be formed. Model standing orders have been prescribed, like in case of Industrial Employment Standing Orders Act. Now for fixed term employment, so legally recognized for first time, equal benefits as permanent employees, and eligible for gratuity after 1 year instead of from 5 years. That is a major change. Not entitled to retrenchment compensation at contract end. So if there is retrenchment, that is say many people have been laid off say due to closure of business, or say scaling down of business. So At that time, they are not entitled to retrenchment, say compensation at end of the contract. In case of layoff or retrenchment, the prior government approval was required only for 300 plus workers. So earlier it was 100. Now only for 300 plus the government approval will be required. And reskilling fund. So 15 days wages for retrenched workers, they have to be paid to the reskilling fund. So this reskilling fund will have to be maintained by all the employers. Coming to the IR code, so trade union recognition, this is the summary table. No formal mechanism was there. Now it is 51% equal to sole union. If membership, any union does not have say 51% membership, then it will be council. Standing orders, they were applicable in case of 100 plus workers. Now it will be 300 plus workers. The threshold has been raised. Fixed term employment, it was not recognized legally. Now it is fully recognized with benefits. Retrenchment approval, earlier it was for 100 plus workers. Now it is for 300 plus workers. Worker definition, so workman definition was narrow. Now we have worker. So it is a broader definition, includes sales promotion employees also. Industrial tribunals, there was single member. Now there will be 2 members in industrial tribunal. Conciliation, so mandatory government referral was there. Now there is direct say tribunal access if conciliation fails. So these are some of the important changes. Now these are the sections under the old act and the corresponding new sections. So in trade unions at section 4 was there. Now in SS code, IR code, it is section 6. Trade unions at section 9 was there. Now there is IR code section 10. Industrial employment standing orders at section 3. Now it is replaced by section 29 of IR code. Industrial disputes act, that is ID act, so section 2 subsection 5 replaced by section 2 7k ZK. Section 7A, that is now replaced by section 52. Section 10 is replaced by section 55 and section 25N is by section 73. Of course, direct mapping is again not possible like in case of say BNS, BNSS and BSA, because here there is drastic change and only 40% of the say, sections are there as compared to the older 29 acts. Coming to the third one, SS code. This is also very important. It replaces 9 laws. So social security code. So extends to organized, unorganized gig and platform workers. I have already told about gig and platform workers. So it will applicable to that also. And therefore, earlier labor laws were applicable only to about 20 crore. Now it will be applicable to more than 60 crore population of India. Previously, it was fragmented coverage across 9 different laws. So gig and platform workers are there. They have been defined for the first time. So they are defined for first time in Indian law. There is also concept of aggregator. Who is aggregator? Aggregator like say Amazon, Ola, Uber, Zomato, Swiggy. These are called aggregators. Okay, so say digital intermediary or marketplace, that is called as aggregator. It is defined in the law now in SS code. Aggregators must contribute 1 to 2% of say annual turnover. That is capped at 5% of worker payments. So they must contribute to this fund for SS, social security. The gratuity, so fixed term employees eligible after 1 year, down from 5 years. Earlier it was 5 years. It is applicable to all categories of workers. So as we have seen, gig and platform workers have been included. Unified registration, so single electronic registration with central government. Aadhaar linked universal account numbers, that is UANs, and portable benefits across states and sectors. And of course, since it is a subject in concurrent list, so the state laws have also, most of them have been notified, rules have been formed, and they are available across websites of different ministries of labor and employment in state governments. Then, if we see the summary, so gig platform workers were not covered. Now they are defined and covered for first time. Gratuity eligibility was 5 years. Continuous service, now it is 1 year for fixed term employees. ESI applicability. Earlier, specific thresholds per state were there. Now it is pan India. So even one employee in hazardous work, so ESI coverage is there even if there is one employee in hazardous work. Provident fund coverage. So it was only for scheduled industries. Now it is extended to all industries. Registration, multiple registrations were there, separate for PF, separate for ESI, etc. Now there is only single unified registration. Wage definition, it was varied across different laws. Now instead of 9 laws, there is uniform, there is 50% rule is there. So wages can't be say less than 50% of the CTC, cost to company. Social security fund, so unified the limited schemes were there for SS fund. Now there is comprehensive fund for unorganized workers and portability. So earlier it was limited. Now there is a full portability via unified Aadhaar numbers. If we see the sections that are replaced, so again one-to-one mapping completely is not possible, but important provisions have been given here. So employees compensation at 1923, section 3 is replaced by section 36 of SS code. ESI Act 1948, Section 2 is replaced, definitions have been replaced by Section 2 of SS Code. EPF Act 1952, Section 6, replaced by SS Code Section 10. Maternity Benefit Act 1961, Section 5, replaced by SS Code Section 45. Payment of Gratuity Act Section 4, replaced by Gratuity Eligibility Section 56 of IS Code, SS Code. Unorganized Workers Act 2006. So Section 3, it is replaced by, it pertains to social security schemes. So it is replaced by SS Code Section 15, Chapter 9. Then we have new provisions that were not there earlier, particularly the gig workers. So SS Code has Section 235 that defines gig workers, and there is complete chapter devoted to this Chapter 10 for gig workers. Similarly, there is new provision for platform workers. That is people who are, say, drivers of Ola, Uber, or say people who are delivering e-commerce goods like say Amazon, Snapdeal, Flipkart, and even those who are working from home, Fiverr, Upwork, etc. on say social media websites. So platform workers have also been included, and SS code. So the section 2, subsection 62 that defines platform workers. Coming to the fourth code, OSH code. So the key provisions include major changes from old laws. So broadened coverage establishment is defined as any place with 10 plus workers, that is trade, business, manufacture, occupation. So that is the definition of establishment. Secondly, factory. We know the earlier definition: 10 workers with power, electrical power, 20 workers without power. Now instead of 10 and 20, it is increased to 20 and 40. That is 20 plus workers with power, 40 plus without power. So this is increased from 10 20. This is the major change in definition of factory. Coming to women empowerment, so they are permitted to work in all establishments and all types of work. There are no restrictions now. Only the woman's consent will have to be taken, and security provisions need to be done. Night shift work allowed with consent and safety measures, and no restrictions based on gender. So this is a major change. Health and safety. So earlier it was Factories Act. So now mandatory annual health checkup for all workers, free health checkup for workers above 40 years, and mandatory appointment letters for all employees. These are the three, we can say, revolutionary provisions that have been included. Contract labor. So prohibited in core activities with limited exceptions. Earlier there was Contract Labor Abolition Act 1970. That is repealed now. Principal employer liable for contractor violations. So we know the difference between employer. Employer is generally, it could be contractor, and principal employer are the people who are, say, government departments or who sign contracts with those, and their status is that of principal employer. They also become party in case there are, say, labor disputes or cases in labor courts. And there is, threshold, that is 50 plus workers. So contract labor, now it is increased from 20. So if there are more than 50 plus, then 50 plus workers, then this contract labor registration is required. Now coming to this occupational safety, health and working conditions code, this is the comparison table. So we can summarize factory definition. Earlier it was 10 20 workers, power or no power. Now it is 20 to 40 workers, power or no power. Women workers, so restrictions on night work in certain jobs, only certain jobs they could do. Now it is permitted in all work with consent and safety. Contract labor threshold, earlier it was 20 plus, now it is 50 plus workers. Core activities, so there was no specific provision. Now there is contract labor prohibited with exceptions. Health checkups, earlier there were limited provisions, now it is mandatory. So mandatory annual checkups. Appointment letters, so no statutory requirement was there. Now it is compulsory for all. So mandatory for all workers. The written appointment letter have to be given, even if that is electronic. And audio visual workers. So earlier cine workers only were included. Now it is expanded to say digital or OTT platforms also. That is a major change. So they have been included. That means the coverage is broader. Interstate migrant workers. So there was separate act. Now there are integrated provisions within this. In Factories Act, these are the sections that have been replaced. So Factories Act 1948, Section 2M, it is replaced by OSH code, Section 235. Factories Act Section 14, replaced by OSH code, Section 9. Factories Act Section 51, replaced by, say, related to working hours, related to Section 13. So we see factory definition, cleanliness, working hours. These are some important sections with which we generally deal with as a welfare officer or factory inspector or, say, advocates. In Factories Act 1948, there was Section 66 for annual leave. So in OSH code, it is Section 16. Contract Labor Act 1970, Section 7 was there for registration of contractors. Now in OSH code, there is 48. Then Contract Labor Act 1970, Section 10 was there. Now under OSH code, this was prohibition of contract labor. There is Section 51 now. Earlier for interstate migrant workers at 1979, Section 13 was there for displacement allowance. Now in OSH code, there is Section 1040 that deals with that. Mines Act 1952 Section 23, corresponding section for health and safety is OSH Code Chapter 4. Plantations Labor Act Section 8, medical facilities. So now under OSH Code we have Section 11. BD Workers Act 1966 Section 4 for welfare provision. Now we have OSH Code Section Chapter 3. There are some new provisions, that is women in all work. So OSH Code Section 43 includes that. And we also have say new provision, that is appointment letters. These have been made mandatory by OSH Code Section 25. So these are some important changes. Coming to the timeline of implementation, how these have been implemented. So legislative journey was 2015 to 19. So extensive consultation with stakeholders were done, management, workers, labor unions. 9 tripartite consultations, third party includes government also. 4 subcommittee meetings were held, 10 regional conferences were held, and 10 interministerial consultations were done. So that is the history. Then coming to the parliament, that is August 8, 2019. So code on wages was notified at number say 29 of 2019. Then on September 29, 2020, the 3 other say acts were notified while the COVID was going on. Industrial Relations Code 2020 notified Act number 35 of 2020. Code on Social Security 2020 notified Act number 36 of 2020. And OSH Code, actually the OSH and Working Conditions Code 2005 to 2020 notified on say Act number 37 of 2020. That is a serial number that is given from January to December. So that is the serial number of that. Then 2021 to 2025. So draft rules published by central and state governments. Most of these are available on the Ministry of Labour and Employment Government of India website. India Code website has not yet been updated, but the codes are available there. And the state government departments are say regularly since last 1 month, the many notifications are being issued. There is phase implementation of certain provisions, particularly related to Provident Fund and say EPF. And some provisions had already come into effect before 21st November. That is important to notice because of one Supreme Court order and some provisions of code on wages like formation of Central Advisory Board, etc. So they had already come into effect, as we shall see. Public consultations on rules were done, and on November 21, say full implementation of all 4 say labor codes except a few 3-4 sections. Now the transitory provision, because that is very important. What is happening now? So during transition period, continuing validity of existing rules, regulations, notifications, we call it subordinate legislation. So these will remain until they are modified by the new laws. Okay, so that there is no anarchy or lawlessness. So existing rules, regulations, notifications, standards, and schemes under repealed laws remain in force until new rules are notified. There is a continuing validity. Second is existing registrations, licenses, and approval continue to be valid until they expire. When they go for renewal or new registration, at the time the new law will be applicable. Section 24 of General Clauses Act 1897 applies. So those who are say you might have studied that in interpretation of statutes in your LLB paper. Pending matters are what happens to existing court cases. Very interesting question for lawyers. So litigation, proceedings, and investigations under old laws continue. Secondly, penalties, prosecutions, and say claims initiated under repealed laws proceed to completion. And rights and liabilities accrued under old laws preserved. Special cases that of EPF Act, as I have told, not completely came into force. So Employees Provident Funds Act 1952 continues for 1 year to extend, not inconsistent with SS code. So that's why 4 sections have not yet come into effect. Maybe they will be notified within 1 year. And there it allows time for smooth transition of all EPF schemes. Now the code on social security. So what are the sections that have not come into effect? So it is partly operational. So major provisions are in force. That is sections 1 to 141, except noted exceptions. 7 out of 9 old laws fully repealed. 2 old laws continue. That is EPF Act 1952, Core PF, and ESI Act 1948, all provisions. Pending is Core PF, ESI Corporation, section 143. So these are yet to be implemented. Maybe they will be implemented within 1 year. That's why I told that we shall have to see the details on this SS code that is not yet fully implemented. Key pending provisions that have not yet come into effect include section 15, subsection 3.4 for Provident Fund scheme, section 16.1a for Provident Fund establishment, section 16.2 for fund administration for PF, section 143 for employment information exclusion, and item 3 of section 164.1, that is ESI Act repeal. So it has not yet been repealed fully. And section 164.2b, that is ESI structures continuation. So that's why SS code needs to be paid particular attention. Now the impact on existing case law, what happens to the court case judgments. So judicial precedent. So general principle is that case law interpreting repealed laws remains relevant where provisions are substantially similar. So if similar provisions are there in new code, the case law remains relevant. And courts will apply doctrine of say perimeteria, that is similar provision, similar interpretation. Now the areas of change. So precedents on workman versus worker, because now the definition has been changed. So new broader definition may require fresh interpretation, because now what Parliament has defined, that is supreme. So they will have to go as per this definition now. The courts will have to see this new definition. Wage definition cases. So 50% rule creates new framework, because definition of wage itself has changed. Standing orders threshold. So cases on 100 workers threshold may not apply to 300 workers when now applied. So these older laws will not be applicable. Now it will apply only if it is over 300. Contract labor in core activities. So new prohibition requires fresh jurisprudence, because earlier it was not there. Now there is new prohibition that apply. Developing jurisprudence. So fixed term employment, entirely new concept. There are no precedents for that. Gig and platform workers, they have been included for the first time. So first time legal recognition. Reskilling fund, it is a new mechanism requiring interpretation. There is no case law available for that. Inspector has been changed to inspector cum facilitator. So there is shift from punitive approach, although the penalties have been somewhat increased. Now the practical implications for employers. So immediate compliance requirements are salary structure revision. So recalculate to ensure wages are 50% of equal total remuneration. It impacts provident fund, gratuity, and other benefit calculations, and may increase employer costs initially. Secondly, registration and licensing. It is much simpler. So migrate to single registration system, update with a unified portal, say where operational, and maintain compliance with state-specific rules. Employment contracts. Since there has to be written letters to be issued. So issue appointment letters to all workers. This is now mandatory. Review fixed-term employment arrangements and update policies on contract labor in core activities, because there are some new restrictions on contract labor. The threshold changes, standing orders. So review workforce is 100 to 299 workers, because now those standing orders are not applicable below 300 threshold. Retrenchment. So greater say flexibility for establishment is 100 to 299 workers. So only if there are more than 300 plus workers, then these provisions apply. Otherwise, retrenchment can be done. No government approval needed. For other implications for employers are social security. So extend coverage to gig and platform workers if aggregator is like Amazon, Ola, Uber, like that. They are called aggregators here. Fixed term employees eligible for gratuity after 1 year. Ensure PF ESI compliance under new definitions. Workplace safety. So annual health checkup for all workers is mandatory. Women safety protocols for night shifts, because they have been allowed to work during night time now. And update facilities for gender neutral workplace, so that there is no discrimination. Coming to IR, industrial relations. So review union recognition processes, because again, this threshold have been changed, whether it is 51% or less than 51% membership. Otherwise, there will be council. Update standing orders if applicable, because there is new IR code now. Prepare for reskilling fund, say contributions if retrenchment is planned. So this is a new fund that is established under the IR code. Compliance systems. So prepare for web-based inspections and train HR teams on new codes and update record keeping systems, because this is all going to change. What are the implications for workers? So firstly, universal minimum wage is defined. So enhanced rights and protections. Every worker is entitled to minimum wage, no exclusion. Floor wage ensures minimum living standard. Timely payment. Earlier there was payment of wages at. So wages must be paid on time to all workers, and no wage calling for payment provisions. No wage ceiling for payment provisions. So there is no ceiling. Appointment letters, these are mandatory for all workers. Formalizes the employment relationship and their obligations. Enables the claim of statutory benefits. So because of appointment letters, all these workers will get statutory benefits. That is ensured now. So that's why the coverage has been drastically improved. Say instead of around 20 crore, it is more than 60 crore population that will be covered now in India. Social security. So extended to gig platform and unorganized workers, portable benefits via Aadhaar linked, say unified Aadhaar numbers, and gratuity after 1 year for fixed term employees. Earlier it was 5 years. Equal opportunities. So gender neutral provisions are there. Women permitted in all work types, and equal pay for equal work. Although there is no equal remuneration acts, because that is repealed and say implemented in the new code. Health and safety. So instead of the earlier Factories Act, now we have free annual health checkups. Even ESI and other acts have been repealed now. Enhanced safety standards across sectors and better welfare facilities. So these are ensured in complete chapters. Fixed term employment. So equal benefits as permanent employees, that is there as per the principle of equal pay for equal work. There is job security through formalized contracts, because compulsory appointment letters will be there. Social security coverage as per the SS code. Like in case of USA, there is social security number. So now there will be social security coverage for all covered under SS code. That includes gig and platform workers also. Grievance redressal, so streamlined dispute resolution, direct tribunal access. So this mechanism has been changed now. Faster adjudication timelines have been given so that there is time-bound justice. Now, as far as legal practice, how does it matter to us as law students or practicing lawyers? So firstly, the advisory practice. So guide clients on compliance under new codes. That will be a booming business now. Say salary restructuring and cost implications, because there are calculations need to be done. All contract say letters have to be revised, contracts have to be reviewed. Transition from old to new legal framework. Litigation, court cases. So new causes of action under courts. There could be new cases that were not there earlier. Secondly, evolving jurisprudence on new provisions. New case law will come. Transitional disputes on applicability. So there could be some, because we are migrating from older laws to new codes. Then the labor code practice for those who are practicing in labor codes. So familiarize with new procedures. Updated standing orders provisions will be there. Fixed term employment disputes will be there. Due diligence. So their advisors can be very much useful and provide advice. Merger and acquisition transaction, that is assess compliance under new codes. Joint liability for unpaid dues in business transfers, and reskilling fund obligations. So these are some new areas that have to be looked into by lawyers. Drafting. So employment contracts under new framework, that's going to be a big business. Fixed term employment agreements, because now everybody has to be given employment letters. Standing orders for 300 plus workers establishments, and gig and platform worker agreements, they have to be drafted. That will be the drafting work for advocates. Then the compliance audits. So multi-state operations, navigate central plus state rules, single registration system implementation, and inspector come facilitator interactions. These are the new areas. Specialized areas, that is gig economy, legal framework. So this is entirely new. Platform worker rights and obligations will be there. Aggregator compliance requirements will be there. Aggregator have been defined under the new act for under the SS code. Core activities determination for contract labor. So gig and platform workers have also been included and defined in the new act, the new code. Dispute resolution. So conciliation and arbitration under new IR code will be there. Industrial tribunal procedures. So there will be two member bodies instead of the single member body. So two member benches will be there instead of just one presiding officer. And compounding of offences provisions are there. So there could be compromise. Then the term worker. Earlier workman, say there was narrow definition. Now worker, so it is a broader, it includes self-promotion employees also. Wages. So it was different across laws. Now there is uniform definition, minimum 50% of remuneration. Establishment. So there was say varied definition. Now there is uniform place where industry, trade unions or trade or business is carried on. That is defined as establishment as per the new definition. Industry. So it was narrow in Industrial Disputes Act. Now it is broader, and all systematic employer worker activities are treated as industry. So definition of industry has also changed. Factory definition has changed. Instead of 1020, now it is 2040. That is with power, without power, electrical power. That is. Then employee. So employee definition has been changed. It was not uniformly defined. Now it includes managerial and supervisory staff also. They have been treated as employees. Then registration. So see what is the simplicity, and under the new law, how compliance is easier and enforcement is also easier for the government. So earlier there were up to 8 say separate registrations. Now there is single unified registration that is needed. Earlier licensing, 3 to 4 different licenses had to be obtained. Now there will be single license. Returns, so multiple returns to different authorities had to be submitted. Now there is single return system. Then inspections, so there were random, and say Inspector Raj punitive focus was there. Now there is the role of inspector is going to inspector come facilitator, advisory plus compliance. That will, they will issue letters first, and if they are not compliant, then the penalty will be levied. Inspection type. So earlier it was say physical, often random. Now it will be say web based as well as transparent say inspection. Penalties. So earlier there were lower fines. Now there will be larger fines, but imprisonment has not been increased. So increase say substantially. There is up to 20 times, 20x as compared to the older, because they were the laws ranging from 1923 to 2008. Then compounding of offences. So earlier there were limited provisions, but now there is more compounding, there is compromise. So structured compounding, there is 50% for first offense. Now what are the challenges in implementation while we are migrating from older to the newer laws, newer codes? Practical challenges include firstly the state rules. That is, labor is concurrent subject. Secondly, states must issue their own implementation rules. Regulatory divergence across states creates compliance complexity. And multi-state employers face different requirements because they are working in different states and different states could have different state rules. Transition confusion. So operating under both old and new systems simultaneously, that is during the transition period, at least for 1 year. Then unclear which rules apply in absence of new state rules because the time has been given that all the older subordinate legislation will remain into force until the new say rules have regulations, notification or government orders have been enacted, pending litigation under old laws. So the old court cases will go on as per the old laws. Third is the definitional ambiguities. So core activities, so not precisely defined. Another problem is customary practice exceptions to contract labor ban. So earlier this was not there. Now contract labor ban is there. So a new provision has come. Platform worker versus independent contractor classification. How to do that? Platform workers have been defined. Cost implications. So 50% wage rule increases employer contributions, gratuity after 1 year for fixed term employees, and annual health checkups for all workers, and reskilling fund contributions. These are employers' obligations. Digital infrastructure. So single registration portal readiness has to be there for the government. State level digital systems development, web-based inspection mechanisms because it will be web-based inspection. Awareness and training. So workers' awareness of new rights, employer understanding of obligations, and inspector training as facilitators, and legal community adaptation has to be there. Then the interpretation issues. Firstly, the new provisions are without precedent. Courts are developing fresh jurisprudence and inconsistent interpretations across states. As far as social security extension is concerned, so practical mechanisms for gig worker coverage, aggregator contribution collection, and benefit portability implementation is there. So these are some new provisions. So what are the opportunities and benefits for the labor ecosystem? Simplifications, that is from 29 laws we are going to 4 codes. Uniform definitions reduce ambiguity, and single compliance window will be there. Formalization, so mandatory appointment letters will have to be there. Social security has been extended to informal sector, and better record keeping will be there because less registers will have to be maintained now, and it could be online also. Transparency. Social security expansion. So coverage increased from 19% 2015 to 64%, that is 2025. So SS has been substantially expanded, particularly because gig and platform workers have been included, and portable benefits across states. Flexibility. So fixed term employment includes, say, hiring flexibility. Threshold increases, that is 100 to 300. It reduces the regulatory burden for smaller industries, smaller and medium, and ensure compliance for easier compliance for small businesses. There is worker empowerment. So universal minimum wage coverage is there. Gender equality provisions are there, and enhanced health and safety protection will be there to workers. Transparency, because there will be web-based inspections, digital compliance systems, and reduced discretion and corruption, because it is a move away from inspector rush to now inspector come facilitator system. So there is less scope for discretion, less scope for corruption. Economic growth. So ease of doing business improved because that was the major objective under our international obligations under the ILO. Attracts investment and aligns with global labor standards. So that will be say attract more FDI, foreign direct investment in India. For different stakeholders, employers reduce compliance burden, that is single window, greater operational flexibility, and say clarity in legal obligations, and reduce litigation uncertainty. For workers, the benefits are universal coverage and protections, portable social security benefits, and that is if they are moving from one place to another, the social security benefits will continue because there will be single SS number, like in case of US. Better working conditions, faster dispute resolution. For legal professionals, new practice areas, that is gig economy, platform economy, advisory opportunities are there, compliance, due diligence, emerging jurisprudence, and increased compliance work. For government, better enforcement mechanisms, digital monitoring systems, improved labor statistics, and policy flexibility. These will be the advantages. So if we compare these, the code and the section definition, so wages, now it is defined in section 2Y, that is all remuneration excluding certain allowances, that is must be 50% of total. Worker is defined, so all 4 codes it varies. So person employed for remuneration broader than workman. So instead of workman, the word is now worker. Establishment, so all 4 codes vary. So any place where industry, trade, business, manufacture is carried on. Employee, so in IR code, SS code, section 2, so it includes skilled, unskilled, managerial, and supervisory staff. Gig worker, defined in SS code, say section 235. So here we have pension performing person performing work outside traditional employer-employee relationship. That is, say, a gig worker. Platform worker is also defined. That is section 262. That is section 2, subsection 62 of SS code. So person engaged through online platform excluded from gig worker. So these have to be separated, gig worker and platform worker. And then fixed term employment. Uh, Although in practice we consider that platform worker is included within gig worker, but it is not like that in the SS code. Then fixed term employment. So all code section 2Y. So worker oriented, worker on contract for predetermined period. That is called as fixed term employment. Now, if we consider the code wage definition, what is this 50% rule? So 50% wages include basic pay, DNS allowance, returning allowance, if any. You may compare that with say Payment of Wages Act, what is included and excluded from wages in 1936 Act. It excludes, but not more than 50% of remuneration. That is house rent allowance, HRA. I have already distinguished between house rent and house rent allowance. House rent is given by employee to employer. House rent allowance is given by employer to employee. So HRA normally it is 10% of, can't be more than 10% of salary. HR could be say 15% is a deduction for those who get quarters from their employers. Overtime allowance normally double the rate of wages. Bonus payable under any law. Earlier there was Payment of Bonus Act, 8.33%. Conveyance allowance, special allowance and allowances and perquisites and any other allowance. These are not included within the definition of wages. This is the new section 2Y. So the rule is that if exclusions exceed 50% of total remuneration, the excess amount is treated as wages. That means this excess amount, this exclusions can't be more than say this inclusions. So if it exceeds 50% of total remuneration, then it has to be there. Total CTC, cost to company. So that is say, for example, rupees 1 lakh. So exclusion say 60,000, that is exceed 50%. So wages will be 40,000 plus 10,000 excess. That is 50,000 because in any case it can't be less than 50%. Okay, so that is the 50% rule. Coming to fixed term employment, new concept. So IR code sections 2Y and 57. So definition is worker engaged for a fixed period on written contract. So key features are all benefits same as permanent workers, that is pro rata, proportionate. Working hours, wages, allowances at par. Social security benefit coverage, that is PF, ESI, gratuity. No retrenchment compensation at contract end if it is as per terms and conditions of contract. Gratuity after 1 year, not 5 years, and can be terminated only as per contract terms. So the impact will be provide flexibility to employers, job security to workers during contract period, and formalizes temporary employment. There are say reduces the organized, say reduces the disguised permanent employment. So there is new definition of this contract employment now. So duration, earlier permanent was indefinite, now it is predetermined period. So this word has been changed. Gratuity after 5 years, now it is after 1 year. Retrenchment compensation was there, now there is no retrenchment compensation if it is at contract end. Other benefits, they were full, now they are equal, that is pro rata, proportionate. Now gig and platform workers. So these have been included for the first time. So Social Security Code chapter 10, gig worker is defined in section 2 subsection 35. So person who performs work or participants in work arrangement and earns from such activities outside of traditional employer-employee relationship. These are called gig workers. That means there is no employer-employee relationship. Platform worker, section 2, subsection 62. So person engaged in or undertaking platform work that is excluded from old worker definition. So they have been included now. And then we have aggregator like Ola, Uber, Amazon, Flipkart. So aggregator are section 2.5. That is digital intermediary or say marketplace platform. Like it includes Upwork, Fiverr, etc., where people are outsourcing their services, even lawyers working for other countries. Obligations. Aggregators contribute 1 to 2% of annual turnover, that is capped at 5% of payments to platform workers. Separate social security fund for gig and platform workers, and benefits are life and disability. These are the important benefits that will be there to gig and platform workers. That is the life insurance, life and disability cover, health and maternity benefits. They have to be given to gig and platform workers also, and old age protection. Significance is first, legal recognition of gig economy workers in India, because that is increasing, particularly after COVID. Extend social security to say millions of app-based workers. So social security, because this has been included in the SS code 2020. Then balances flexibility with protection. Now registration and licensing. So there is unified system. It's going to be simplified. So old system was multiple registrations required. Factories add registration, shops and establishment registration, contract labor registration, EPF registration, ESI registration, professional tax registration, trade license, labor welfare fund registration. Now, instead of that, it will be only single registration. So, new system, single unified registration with central or state government. One regulation covers one registration covers all four codes. So, there will be no separate registration for four codes. Aadhaar linked for establishments. Electronic platform, that is Shram Suvidha portal is there. So, on Shram Suvidha, it can be done. It's a government portal. Single return filing system. Only one return needs to be filed. Portable across states. So portability is the big advantage, even if there are offices in multiple states for larger companies. Benefits include it reduces time and cost, eliminates duplication, increases formalization because there are formal appointment letters to be given, easier compliance monitoring. So it can be done through portals also. Coming to role of inspectors. So paradigm shift from inspector right. Old system was inspector had wide discretion, and discretion means nothing is written what is to be done, what is not to be done. So now there will be less discretion. Focus on finding violations. Earlier it was punitive approach, harassment and corruption concern, and multiple inspections by different departments. Now under new system there will be inspector come facilitator. So the dual role is enforcement plus advisory. That means they will advise, they will issue letters for compliance. So web-based transparent inspections will be there. Prior notice with 72 hours advance intimacy. So it will not be like raid. It will be 72 hours intimation has to be given. Video recording of inspection will be done. Checklist-based inspection. So there will be standard checklist. Single inspector for all codes or four codes. First offense, so advice to rectify. And then penalty only on continued non-compliance. So that is how there is change. Provisions are OSH code section 84. Other codes have similar provisions, and joint monitoring is possible for this. Joint inspections are possible under these four codes, and compliance-based inspections are also allowed. Now, reskilling fund. This is a new concept. So under IR code section 74, it is a fund for retraining the retrenched workers. That means after they have been retrenched, they will have to be retrained. Enables employability in other sectors. That means what we call as out placement. उनको दूसरी जगह नौकरी ढूंढ कर देना. Contribution. So employer pays 15 days wages per completed year of service, deposited before retrenchment, and administered by government. So government will administer this reskilling fund. The eligibility is worker retained under section 73. That is establishment with 300 plus workers. Training provided within prescribed time. Purpose is it softens the impact of retrenchment, enhances worker adaptability, promotes lifelong learning, because there will be it's actually for training, reskilling. Already we have Skill India and other projects that are going on. Aligns with NSDC is there, National Skill Development Corporation. Aligns with Skill India passion. There is no equivalent to old laws. So earlier this concept was not there, reskilling fund. So complex, it is completely new social security measure is there, and it balances employer flexibility with worker protection. Coming to the OSH and working conditions code. So major changes are night shift work is permitted, section 43. So women permitted to work in all establishments, can work in all shifts including night with consent. Safety measures are mandatory, that is transport, toilets, security. They have to be provided for women. No gender-based restrictions. The old law Factories Act, they were prohibited women's work between 7 p.m. to 5 a.m. That is repealed now. All types of work. So no prohibition on dangerous or hazardous operations subject to their consent. Same safety standards for all genders and equal opportunity. Maternity benefit under SS code. So 26 weeks paid leave and 12 weeks for third child onwards. Work from home option is post maternity. So work from home is a new concept that is implemented. Creche facilities for 50 plus workers establishment, and they need not establish. It can be outsourced if they don't have their own creche for children. Equal remuneration, that is code on wages. So gender neutral provisions are there, includes transgender persons, and equal pay for equal work is implemented. Standing orders, so threshold change under IR code chapter 4. So old law was the Industrial Employment Standing Orders at 1946. Now it was applicable to establishment with 100 plus workers, section 1.3. Under new code, applicable to establishment with 300 plus workers, and there is section 28. Now what are standing orders? So these are the rules governing employment conditions, that is classification of workers, working hours and shifts, holidays and leave, attendance and late coming, and termination procedures, misconduct and disciplinary action, wages and wage periods. So all these will be covered under this new instead of standing orders, it will be covered under SS, the working conditions. Then impact of threshold change. So establishments with 100 to 299 workers no longer need standing orders. It reduces compliance burden for medium enterprises. greater flexibility in employment term and applies prospectively from implementation date. So भविष्यलक्षी प्रभाव से, भूतलक्षी प्रभाव से retrospectively लागू नहीं होगा. Core say core activities are contract labor say prohibition. That is a new provision under OSH section 51. So contract labor prohibited in core activities of an establishment. Core activity is defined as activity for which the establishment to set up and explicitly defined creates interpretative challenge because definition is not so clear. And exception is say there is incidental or ancillary activities, work of intermittent or seasonal nature, and work according to customary practice of the area or industry. These have been accepted from this prohibition. Examples are interpretative, so manufacturing company, production line core, canteen security non-core, bank is a banking operations is core, housekeeping for them is non-core activity, hospital medical services are the main thing, core activity, laundry is their say non-core activity. So non-core say this is how core activities have been distinguished from non-core activities. Legal challenges, core activity will require judicial interpretation. So more case law will have to be evolved. Customary practice exception provides flexibility, and circular by industry ministry is expected for clarification because some subordinate legislation is likely to come soon. Old law was contract labor at 1970, so no specific prohibition on core activities was there, and abolition was required. Required government order. So that is the change. So threshold comparisons across codes, these are critical. So factory definition has been changed from Factories Act to OSH code. Standing orders. So now it will be 300 workers. Retrenchment approval for 300 workers. Contract labor registration for 50 workers under OSH code. EPF applicability to all, that is 20 workers. It remains unchanged. ESI applicability, 10 workers remain unchanged, at least for 1 year. Because EPF and ESI older provisions continue for 1 year. The 4 sections remaining will be implemented in the next 1 year. And then gratuity applicability, period of gratuity act. So now it will be 10 workers unchanged. So the impact of this will be smaller establishments enjoy relaxed regulations, more establishments now outside strict regulatory framework, balance between production and ease of doing business. The penalties have been changed. So minimum it was 10,000. Previously it was 1,000 to 3,500. Maximum now it is 50,000. Previously it was 7,500 to 37,500. Up to 10% increase is there. Under IR code, imprisonment up to 3 months, fine up to rupees 1 lakh. For continuing offense, rupees say 1,000 per day. SS code, imprisonment up to 3 years, fine up to 1 lakh. Substantial increase from old ESI, EPF penalties. OSH and working conditions code, imprisonment up to 2 years, fine up to 2 lakh rupees. Death due to negligence up to 3 years imprisonment. Compounding of offense, first offense 50% of maximum penalty, subsequent offenses 25% of minimum penalty, maximum penalty, sorry, and encourages early settlement. Then there are these dispute resolution provisions that have been changed. So I hope we shall stop here.
Sir, registration form had one query. How effective do you think are the new codes?
Yes, they will be very effective because see, this is a event that has happened after say 75 years after independence, and maybe we can say after 100 years. That is 102 years actually after 1923 when Boilers Act and this Employee Compensation Act were enacted. So this is for the first time that so much say complexity because entire this starting from say industrial revolution onwards, it was all as per the 19th or early 20th century, and this 21st century needed new laws. So I hope it will be, and it was a well drafted exercise because it was going on since 2015, and even after the act was passed, we see that there is great change. That is, we can say delay. I mean, 5 to 6 years, because all the state governments had to be communicated. All the say state governments have drafted their laws. Most of them have already been circulated, and these are widely. And I think some of these have also been taught in law colleges and law universities. Now that they have been implemented, and suddenly there is, I think, a great compliance work drafting opportunities for lawyers and law students because they can do this. And since the population is considerably increased, earlier it covered only 20 per crore. Now it is more than 60 crore workers will be included within this new code, and there will be more and more awareness because of these provisions. See, actually, I had started my study of labor law in 1987 when I was in third year Polytechnic in diploma in electrical engineering. So after that, now I suppose there is drastic change, and that's why it is a one-time event. We can call once in a century event, just like in case of criminal laws. These have been changed after 160 years. Similarly, in case of labor laws, although older say few laws like about 20-25 laws remain, because labor codes implemented around 51 different acts. So now 29 acts have been reduced to 4 code. So that's why there will be a drastic change. Yes.
Okay, sir.
My question was about with respect to the POSH Act, because in
Yeah.
the 2013 central government rules, the
Mhm.
appeal remains before, as per the industrial.
Actually, POSH Act is a civil act. Okay, it deals with only with the employers. So there are no criminal provisions, and there are internal complaint committees (ICCs) that are there at national level, state level, or say district level, and even at say university, schools, colleges level. So it's a civil law that mainly regulates employer relationships, and there is no criminal law involved. For criminal law, we of course have say BNS Chapter 5, that is offense against women and children. So we need to understand the scope of the POSH Act first. So if there are serious offenses, they won't be covered under the POSH Act. So POSH Act is included within the code of conduct. So that is there, and there is no change in that. And the other provisions of POSH Act will continue. As far as the harassment is there, so workplace has already been defined under POSH Act. So what is called workplace, what is called sexual harassment, how is it different from, what are the say mandatory reports that have been sent by the ICC internal complaints committee, and where there is no coverage. So at that time, the say complaints go to the district committee, states committee, and national committee. So those provisions are quite clear, and I suppose that is not going to be affected because of this. Another question in chat is, please shed light on extent of applicability to employees of private listed companies. Yes, it will be applicable to that also, because all the say companies where the labor laws were applicable, now it will be applicable to private listed companies also. Does this code reduce the bargaining power of unions? Well, I suppose not, because instead of unions or multiplicity of unions, now if there is more than 51% membership under the Trade Unions Act, it was already permitted. So now there will be trade union, or there will be a council of trade unions. So if there are multiple trade unions such that no union has 51% or more than 51% membership, then there will be a council of trade unions. So that is the new provision. So I suppose that doesn't reduce the bargaining power of unions. But of course, 14 days notice has to be given before strike. So these things have been specified under the IR code. And as far as retrenchment and these things are concerned, so instead of 100, now there is 300 plus, because say because of ease of doing business, and some small and medium say enterprises have been given some relief under from implementation of the new laws. So that is a, we can say, important change. That is, the definition itself has been changed. So these provisions we have already seen. So that doesn't reduce the bargaining power of unions, but I think unions also need to be aware of the benefits, because initially there could be some say reskilling or say relearning that needs to be done, but in the long term it will be beneficial to the employees themselves.
Sir, as
Yes,
you
yes.
said, this POSH Act goes under the civil offenses, means
Yes,
civil
yes.
cases. So,
Yes,
sir,
yes.
if there is a misconduct by a
Mhm.
government officer, any
Mhm.
office government, if
Uh-huh.
they misbehave with the stranger person, ladies, when they go
Yes.
for some inquiry in the government offices, like example, they send some vulgar envelopes by post
Mhm.
to their residence or any greeting cards. So
Mhm.
how to cover these cases if they won't go under the POSH Act? Are these then criminal offenses?
No, these are not criminal. See, there actually we have different provisions under civil and criminal. Firstly, the definition of sexual harassment. Okay. So these have been, there is civil definition, and it has been clearly defined under the POSH Act. Okay. That is a demand of sex from a woman, or say obscenity, and other things are there. So these are the say civil misconduct. See, we have to understand the purpose. Already there was 354 under IPC. So 354 is a criminal offense. And after the Nirbhaya gang rape case, there were 354A, 354B, 354C, and 354D also. Now, all these have been brought under BNS Chapter 5, that is offenses against women and children. So, criminal, see, we have to understand the difference between civil and criminal remedy. Civil का मतलब नौकरी से निकालना या employer relationship को govern करना. There could be different types of punishment. जैसे government employees है, so there are 4 minor penalties, 4 major penalties. सो एम्प्लॉयर किसी को जेल नहीं भेज सकता, और पुलिस किसी को नौकरी से नहीं निकाल सकती. दोनों के अपने अपने पावर होते हैं. तो पुलिस का जो है वो जेल घर रखना कि जेल भेजना. सो फॉर क्रिमिनल लॉ द डेफिनेशन ऑफ सेक्सुअल हरासमेंट रिमेन्स विद इन चैप्टर 5. वो पहले भी था 354 एंड 354 ABCD. Now we have, as far as the definition under the code of conduct, जैसे उत्तराखंड में भी है, we have this code of conduct that is included under the 2002 conduct rules, and even this sexual harassment is included in say conduct rules of most of the civil service or in employment rules. So that definition is same as the definition under the POSH Act. So that is a civil remedy, and those definitions are almost similar. If you see the civil and the criminal definition, the only thing is remedy is different. Civil में employee पे action ले सकता है, जेल नहीं भेज सकता, minor या major penalty दे सकता है, and under criminal remedy, say there could be imprisonment as well as fine. So that is the say major change between these two different types of remedies. As far as definitions are there, no change is there. If you observe the definitions of sexual harassment under the say POSH Act as well as definition under the say chapter 5 of BNS. So I hope it will be clear to you. Sir, I would like to ask you, like after enforcement of new 3 criminal law, all old cases are still governed by old criminal law. Does the same thing will be applicable for this new industrial law too? Please kindly inform me about the same. Of course, old law will be as per the old because the cause of action is there and pending litigation is there. So as per the general clauses at 1897, all the old cases will go on as per the new old laws. And the new cases that arise, that is where the cause of action arises after 21st November 2025, then they will be governed by the new laws. And similarly, remember that the older rules, regulations, notifications, government orders, all are valid until they are expressly repealed by the new laws. And many state governments have already notified, but some laws have to be notified. So it is not only the major acts that we consider, but we also have to consider the minor subordinate legislation. That is also important to be because there are rules, regulations, etc. One question is per wages definition, ESIC is applicable on basic plus DA plus say rate allowance or gross salary. See here, ESI for continuity, it has not yet been fully implemented. The ESI is there, but for wages definition, this ESI C, it should be ESI actually. Employee State Insurance C is corporation. So it is applicable on basic plus DA. Yes, that is because of 50% rule, the definition of wages itself has changed. Okay, and since the definition of wage itself has changed, therefore now ESIC will be extended or it will be extendable or applicable to more number of employees as compared to the previous one. पहले एम्प्लॉयर क्या करते थे कि कानून से अपने को बचाने के लिए वो ये करते थे कि CTC देखते थे, कॉस्ट टू कंपनी, और डिडक्शंस कुड बी मोर देन 50%. अब उतना नहीं हो सकता है बिकॉज if it is more than say less than 50%, then the remaining part will also be added to the wages. तो जो wages की जो definition change कर दिया उसकी वजह से applicability बढ़ेंगी. There is one tax collected under profession tax. Will it be repealed under new codes? No, as far as taxation laws are there, no change is there. But yes, we will have to remember there is the Income Tax Act 2025. So now the old income tax law of 1961 has been repealed. So tax is that is included, and now say that will be changed. The act itself has changed. There is new act that has been passed by the parliament in 2025. That is Income Tax Act 2025. Earlier it was just a bill, but now that it has been passed and it will be implemented from 1st April 2026. That is from new financial year. Therefore, we have to be prepared for that also, because that requires detailed discussion, and labor law is a very important paper, and complete one. Normally it's in 5th semester in 3-year LLB. It is also there in 5-year LLB, and for practicing advocates as well as those who are practicing particularly in labor courts. And since there is contracts, appointment letters, everything has to be rewritten. So even tender notices for manpower, contract labor, the Abolition Act, many laws have changed, Maternity Benefit Act and the Factories Act, IR Act. So many acts have changed, Trade Union Act, and therefore it has, I think, the new opportunity also as well as challenge for the lawyers and law students. So definitely we should take advantage of that, because the laws have already come into force and it was a long awaited reforms, and the exercise was going on since about 10 years, that is 2015 onwards, from drafting of legislation to the passing and implementation. And it will go on for 1 year at least more until the remaining 4 sections of SS code come into effect. Thank you.
Okay, sir. Thank you so much, sir, for giving us clarity on the subject, for presenting your insights on the new labor codes. We really got to learn so much from today's webinar. Thank you so much, sir.
Thank you, madam. Thanks to PLEA and thanks to all participants also.